My name is Neel. I'm a neutral at JAMS, specializing really in arbitration, being a special master, and also neutral evaluations. I was a Superior Court judge in Massachusetts for more than 18 years, and in the last 3 of those years I presided in the Business Litigation Session. I would say my style as an arbitrator is very similar to my style as a judge. It's very important to me to have a full understanding of each side's arguments and their positions. I think it's really important to let the attorneys try their case, particularly in an arbitration where the possibilities of appeal are very limited. So it's really important in arbitration for the attorneys and the parties to feel like they had a fair shot of presenting their side of the case. Much of what I've done as an arbitrator and certainly on the bench has to do with employment disputes, commercial transactions of all sorts, contract disputes that never ceases to amaze me how many contracts can be read in more than one way, insurance disputes, coverage cases, and other issues around insurance, and professional liability cases. As a neutral evaluator, I rely on the hundreds of jury trials and jury waive trials that I conducted as a judge, and certainly the number of the many arbitrations and other neutral evaluations actually that I've done at JAMS. And I think that those experiences and what I've learned gives me a really good foundation for helping one side, because a neutral evaluation is helping one side, determine not only the strengths and weaknesses of the case, but how those strengths and weaknesses may play in front of a fact finder, either a judge, an arbitrator, a jury. There are certain cases where you sort of expect there are going to be moments during the arbitration hearing where emotions come to the surface, certainly employment type cases and others, but human beings are behind those cases and people have strong feelings sometimes. To me, the important thing is to be able to keep track, sort of be aware of the emotional temperature of the room. I think I'm able to tell when people need a break to get control of themselves if they're angry, or to sort of collect themselves if they're sad. That's an aspect where my ability to be extremely patient and be a good listener is important and makes a difference to litigants and to their counsel. I think that's really important for the people who are involved in this.